Hi, this is Nick Critelli, your Ethics and Conflicts Counsel in Des Moines with today's video brief. We want to welcome Frank Hoyt and our friends at Midwest Lawyers who bring this brief to their law firms. We hope they find it useful. Now, last Friday, the Iowa Supreme Court decided a case concerning trial strategy and tactics. Peter Riley out of Cedar Rapids did a great job of convincing the trial judge to grant a new trial as a result of the admission of a questionable exhibit. But Joe Harris did an equally good job for his client at the Court of Appeal and the Supreme Court. So let's go to Suzanne for today's video brief.
Loehr versus Mettile. Loehr versus Mettile provides an all too familiar scenario where a party's inattention to detail in little matters can have large consequences in the courtroom. The fighting issue was whether an oral ultimatum and a cell phone call by Mettile to an insurance adjuster claiming that he would only stay on the job of repairing the Loehr's water-damaged home on the condition that Mrs. Loehr sign off on each work item as it was completed. Mettile claimed that on the call the adjuster said he would confirm the terms of the ultimatum with the Loehrs and later called Mettile back and confirmed that the terms were satisfactory to Mrs. Loehr. To support the meeting of the minds to the terms of the ultimatum, Mettile offered evidence that thereafter Mrs. Loehr signed off on each item and that other conditions of the ultimatum were met by the Loehrs. While the insurance adjuster had only a vague recollection of the cell phone call, the Loehrs flatly denied knowing about it. In response to their denial, Mettile offered into evidence what purported to be a copy of his cell phone records showing calls to and from the insurance adjuster at the time in question. The cell phone records were received into evidence without objection. After the evidence was closed, and during the reply to defendant's final argument, counsel for Loehr's disclosed to the jury that the cell phone exhibit appeared to be false and did not contain the calls that Mettile claimed were from his cell phone. Instead, the records were a composite from Mettile and two other individuals' cell phone calls. The jury returned a verdict for Mettile on the Loehr's claim for defamation and other tort-based claims, but denied Mettile judgment on his counterclaim against the Loehrs for payment for work performed on the home repair. The Loehrs motioned for a new trial, but Mettile resisted on the basis that the Loehrs failed to preserve error by not objecting to the exhibit. However, the district court granted the motion, finding that Mettile's conduct was intentional and an attempt to mislead the court. On appeal, the Supreme Court recognized two options for a new trial: a motion for new trial filed by a party, and a new trial granted by the court in the absence of such a motion. Justice Manfield recognized that the 1966 holding in Schmidt v. Jenkins Truck Lines requires preservation of error, either by objection or appropriate motion as a predicate to the motion for a new trial. However, he also acknowledged that since 1859, the court has recognized that the court has the inherent power to grant a new trial in its own right. The court concluded that preservation of the record is not a predicate when the court, on its own initiative, grants a new trial. But that's where the distinction ends. The standard of review on an appeal treats both motions the same. Misconduct and substantial prejudice must exist to support the grant of the motion. This is where the Loehr's case began to crumble. The Supreme Court's review of the extensive post-trial record differed drastically from the conclusion of the district court regarding the requirement of misconduct. It found that the mistakes in the cell phone record were not the result of intentional misconduct. Instead, they resulted from careless reading and negligence. Next, the Supreme Court reviewed the record for evidence of prejudice that might have resulted from the exhibit. In this regard, it took notice of the trial tactics used by Loehr's counsel. It noted that the lawyer did not object to the cell phone record when introduced into evidence, nor did he actively cross-examine regarding the exhibit or ask to reopen the evidence to deal with the exhibit. Instead, he chose to address the exhibit's defects in his rebuttal to Mettille's final argument. The court concluded, neither misconduct nor prejudice was shown, and if anything, it appears that the Loehr's counsel was able to exploit the defects in Mettille's exhibit successfully.
Okay, so what's the lesson? Actually, I think there are two. First, always check over the exhibits. Make sure they're accurate. Spend as much time preparing your exhibits as you do your client for court. Remember, the exhibits go back into the courtroom, into the jury room with the jury, but the client doesn't. Second, don't get tricky. If an exhibit or a witness's testimony turns out to be defective and you have a judicial remedy, use it. Don't opt for the gotcha moment. This is a classic reminder to us trial lawyers. Not only must the client win before the jury, but we must also try the case so the client can win in the Supreme Court. This is Nick Critelli in Des Moines. Thank you.